Hey everybody, it's Joel Williams and Jared Easter at Williams ELLEBY. Today we want to go over a topic with you that's kind of seasonal, and that is slip and falls on snow or ice or other weather conditions and how the laws of the state of Georgia apply to those. So if you've been a victim of a fall because of some weather condition, there's certain things you need to know so you can determine a successful claim. So Jared, if somebody finds himself in that position, what is the most important thing that you think they need to consider first?
Well, I think it depends on the situation. With slip and falls and the law in Georgia is it's not super complicated, but it is a little complicated depending on where you're at and why you're on the premises where you fell. Okay,
so we need to find out like why they're there and what caused them to fall.
Yeah, so essentially there's the law views it as three types of visitors that could be on a premises. You can be there as an invitee, you can be there as a licensee, and you can be there as a trespasser. And depending on how the law views you, it's gonna control what type of duty or responsibility is placed on the landowner to keep you safe while you're there.
Yeah. So let's talk about invitees, licensees, and trespassers and what those actually are. So an invitee, the most common example, is going to be if you are a customer at a store. You're there to do business with them. There's a mutual benefit for you and the landowner of you being there. A licensee is like a social guest. If Jared was having a party at his house and he said, hey Joel, you want to come watch the Georgia-Tennessee game and watch Tennessee get their butts handed to them?
Maybe this year. We'll see.
But a social guest of someone, and then a trespasser. I think everybody knows what a trespasser is. That's if I go to Jared's house and I'm not invited and I'm sneaking around doing stuff I'm not supposed to do. So the duty that the law imposes on a landowner or property occupier is different, and the highest duty is owed to the invitees. There's a lesser duty owed to licensees or the social guest, and the least amount of duty is owed to a trespasser, although there is still some duty owed to a trespasser. So let's focus on what we see most commonly, and that's the invitee status, like if I went to a store to purchase something. So in the state of Georgia, what does the law require the business owner or the property owner to do as far as its business invitees go?
So as it relates to an invitee, the property owner owes a duty of reasonable care to keep his premises safe from hazards that he knew or should have known about. So essentially that means that anything that the property owner is on notice of that could be a hazard or could be dangerous, then the owner needs to take reasonable steps to mitigate or get rid of any of the dangerous conditions so that his invitees can be safe while on the property. And the interesting thing also is the other part, the should have known part, and that's considered constructive knowledge. So in Georgia, it's not just the things you knew about. So if you knew your steps were broken, obviously as the landowner, you need to repair that. But it's also if you should have known they were broken. So just because the steps are broken at the restaurant and the owner hasn't been there and saw the broken step, he still could be found to have failed his duty to take reasonable steps to fix it from not inspecting it or doing things of that nature to know that it was broken. And there's a lot of other more dense facts related to constructive knowledge, but I think that's a pretty easy example of the should have known part.
Yeah. If it's been broken and you don't have actual knowledge of it for 2 weeks, yeah, you probably should have known about it. If it was broken for 30 seconds before somebody fell over it, yeah, you're probably not going to win with the constructive knowledge argument.
Correct. I think time is a huge factor in terms of how long it was broken. I know there's some case law out there for certain things that if it's been there for 7 minutes or longer, then the law will determine that the owner or the employees of the business should have known that the hazard was there.
Yeah, all of those things are very fact specific and depending on the hazard, but let's talk about specifically, since this video is over weather related premises liability or fall cases, let's talk about situations, in Georgia where it's kind of rare that we're going to get a snow or ice event. It's more common that we get a heavy downpour where there may be puddles of water and things like that. But let's talk about steps that landowners or occupiers should take when there is a snowstorm, there is an ice storm, or there's one on the way. So what would you suggest if you're talking to somebody that owns a business to minimize their risk of somebody falling and getting hurt on their business? What would you do, like if you know, hey, this weather system's coming in, or there's a possibility that there could be snow and ice?
So an interesting thing, and I've had quite a few of these cases. I know we think nowadays, temperatures are pretty mild in Georgia. We don't have those big winters, but I've seen a lot of parking garage cases where it's a big garage, there's a lot of stairs, there's a lot of areas that are elevated. So I know we've all seen the signs on the interstate that bridge may freeze before the road does because of the elevation. But, common things to look for are those corners that don't get sunlight, so that if there is a puddle, there's not really any sun to warm the area. So you might go out to make sure you put salt in that part of your parking lot or that part of your parking area. Sidewalks, stairs are also that same thing. It's elevated. It could be in the shade. They could be covered. So it's important just to, walk the property, make sure that if there are areas with standing water, areas that don't get sunlight, that you take steps either through ice or sweeping, drying the area, putting out mats. If it's something that recurs often, you might consider some sort of a warning, because you can also just provide an adequate warning to the general public or invitees that are coming that this is a dangerous spot, and usually that can, not always, but often absolve you from liability if you do have an adequate warning that the problem could be there or is there. If you know the ice is there, you can't clean it up, put out a sign, do something. Whatever you do, don't look at it and then leave it, because that's pretty much the worst thing you can do.
Yeah, and it really does come down to using common sense sometimes. Like, just do things like monitor the weather. Like, if you know it's December, January, February, you got to keep an eye out for these type storms. If it comes in there in the middle of the week when your business is open, just take adequate precautions. Have the salt on hand.
Just have a plan.
Just in case it's needed. If you have underground sprinkler systems that are set on an automatic timer, don't let them spray water all over the place before freezing temperatures come in. I've had a couple of those cases. So the owner has that duty to exercise ordinary reasonable care to keep their customers safe, but the customers don't just get a pass. The customers also have to exercise care for their own safety. So it's really difficult to win a case where there is a fall in an open parking lot or just in the entrance of a door, if you fall there because of water or snow or ice. Because the way the law works is if the person who falls has or should have equal or greater knowledge of the hazard than the property owner, then the person who fell cannot recover, right? So the whole thing is constructed around who has the greatest knowledge of the hazard. So like the example that Jared gave about there might be an accumulation of ice or snow in the corner of a parking garage or something like that. Well, in those situations, the reason that you can succeed on those cases a lot of times is because it's almost a hidden hazard. Like, the property owner should have the knowledge of that if they're exercising ordinary care, whereas the person who just happens to turn the corner to walk down the stairs may have no clue it's there, and they've just walked all the rest of this premises and there's nothing there. But if you pull up into a parking lot outside of a store and there's ice all over the parking lot and you're slipping and sliding going in there, and then you get out and you fall on ice, good luck. Yeah, it's probably not going to recover for that, because the law is going to look at it and say, hey, look, you had just as much knowledge as the store owner did that this ice was out there. So that can be a real tough road to climb. But like we said earlier, all of these type cases are very fact specific. So if you find yourself in a situation, it's never going to hurt to reach out to a lawyer, whether it's us or any other personal injury law firm in the state of Georgia, and just go over the facts so you can get an idea of, is this worth it? Should I take this route? Should I even bring a claim? And if I do, what challenges am I going to face, and what do I need to prove? Because you can run your specific issues and your set of circumstances by a lawyer, and just get that advice, because most personal injury lawyers are going to give you that initial consultation for free anyway. Okay, so Let's talk about if you talk to the lawyer says, hey, I think you have a good case here. There's 4 things that you have to prove. We already talked about one. That's the duty that the landowner owes to you. And we've been specifically talking about invitees or business customers. But there can be situations where there's a whole lot of negligence or intentional acts where a licensee, a social guest, or a trespasser could prevail. But those are much rarer. But you have to prove what that duty is. You have to prove that the landowner breached that duty. Either they did something or they didn't do something that causation is the third one, the injuries and damages, which is number 4 that you seek, right? So to prove duty, that's not so hard. You just have to gather all the evidence about what happened and what the situation is, what type of legal category you would fall into as your status at that property, and say, okay, well then Walmart owed me a duty as an invitee because I was a business guest of this, or Jared owed me this duty because I was his social guest. And then you can make that determination of, what exactly they should have done or didn't do as far as duty goes. But then you want to talk about breach?
Yeah, and that's kind of picking up right where you left off. What did they or did they not do? And that is the breach. Is once you've established, is it a duty to act reasonably, or with a licensee, is it a duty to not willfully harm someone? Then you look to breach. Did they do something or not do something that breaches that duty owed? Or I guess in layman's terms, did they act reasonably for an invitee? Was what you're saying they didn't do something that a reasonable person would do in those circumstances? If it's, you're an invitee and you're able to say that Walmart knew there was ice right in front of their front door, but nowhere else, would a reasonable person try to melt the ice, clean the ice up, put up a sign? It is just the analysis of, did what they do kind of violate what a reasonable person would do under those circumstances? Yeah.
And if you happen to fall into that social guest or trespasser situation, it's going to be a lot harder. One of my favorite, we're coming up into the holiday season, one of my favorite parts of any movie ever is Home Alone, when the 2 robbers come to Kevin's house and he has all the booby traps set for them, right? Well, I think a robber would have a really hard time recovering. Although it could happen, I don't know if I would take that case.
I think didn't we learn law school trap guns? You can't set up a gun to kill somebody if they come to your house.
Yeah, he did shoot not Marv, but Harry.
Harry
shot him between the eyes with a BB gun.
I don't think you can do that. So a trespasser, there, you do win on you can't set up a gun to shoot someone if they break into your house. So there is that duty for trespassing.
That's right. And I'm kind of thinking about when he sprayed the water on the front steps.
Yes.
If I have front steps and I think, hey, Jared's coming over to the house, watch this. I'm going to spray ice on him, or water, it's going to freeze. I'm going to watch him through my Ring doorbell, and he's going to flip backwards and land on his backside. Yeah, he can sue the crap out of me for those injuries because I intentionally set him up to be injured. But outside of something extra like that, we'll just put it that way, it's pretty tough. The third thing you have to prove is causation. So we got duty, breach, causation, and causation's pretty simple. It just means that whatever that negligent act was actually caused the damages that you seek. So if you say that your back was injured in this, or you broke your ankle, or you sprained an elbow or wrist or something like that, you have to prove that event, that negligence, was the cause of those injuries. In other words, it wasn't, you didn't already have that injury before this happened, or nothing happened after the fact where you injured yourself. You just have to prove that these injuries you're claiming were caused by that event. We usually do that by medical testimony. We'll have doctors give depositions or write what we call medical narratives that will explain why they believe that event or that negligence caused the damages that you're claiming. And go ahead.
Sometimes that can be really simple, and sometimes that can be really complicated. It's easy. You fall, you break your arm. Your arm wasn't broken before you got to the premises. Those are the easy ones. But I think where Joel and I spend a lot of our time in our practice is the nuanced ones, the ones where your back might have been hurting a few months ago, or your back might even have been hurting a little bit the day you fell, but then you fall and it's a totally different pain and it hurts a lot worse, and now you have numbness, or now you have something else going on. And the effort that goes into trying to prove that the fall caused an injury versus you having an injury already can be difficult. There's a lot there that, I think that's where we spend a lot of our time on a lot of our cases, is figuring out, did it cause this? And having an attorney to help can be huge.
Because believe it or not, most of our clients are not 18-year-old young men and women who have not lived life already. And most of our clients have something going on. They've got some arthritis, or they've got a prior injury, or they've got whatever, and we just have to get the evidence together to distinguish between what's unrelated to the fall and what is related to the fall. The fourth thing is damages, and that's pretty simple. It's simple to say, it's more difficult to prove. So damages means, what are you asking to be compensated for? And that can be economic damages, like your medical bills. It can be time you've missed from work, from lost wages or lost profits or lost opportunity. And then there's intangible things like pain and suffering damages, where you have to try to figure out, how am I going to get the insurance company or the jury to compensate me for an intangible thing that you can't easily just add and subtract like you can lost wages or medical bills. You have to try to explain, well, this person suffered this amount of time to this degree and is likely to suffer this amount of time and to this degree into the future, and this is what we believe is a fair amount for that. And sometimes the juries will go along with you and say that sounds reasonable. Sometimes they won't give quite as much as you ask for, but the goal is to get a reasonable and fair recovery for all the types of damages, so that the client, or you, if you're not our client, is fairly compensated for the injuries that you received. So duty, breach of that duty, causation, and damages. Anything else you can think of that we need to cover regarding falls and weather conditions?
No, pretty simple.
Okay. Jared actually wrote a blog about this that actually has some citations to different laws in the state of Georgia and different statistics and things like that. So what we'll do is we'll put a link to that blog in the show notes if you want to dig a little deeper into this and actually have the citations and the law to go along with what we're telling you. But yeah, we appreciate your time today. Thanks for joining us. If this video has been helpful, give us a thumbs up, hit that subscribe button, or we will see you next week.